Good evening, everyone, and welcome. My name is Franny Eberhardt. I'm the president of Friends of the Upper East Side, and we are a 38-year-old organization dedicated to the architectural legacy, livability, and sense of place of the Upper East Side. We welcome newcomers to the second session in the series, and I welcome back many of you, I hope, who were with us yesterday for a fascinating talk by Andrew Dolkart. This is an ambitious four-part series for us. All of them will be videotaped. Last night's was videoed, and it is ready to launch onto our website, perhaps by the end of the day or tomorrow. So if you missed yesterday or want to return to it, you will be able to do that so that you can get the full picture of this very important case and this very important story, which has engaged Friends almost since the beginning of our existence. Our videographer, by the way, is the company is called Rustic, and they did a video also, which many of you may have seen, the history of Yorkville, which you can find on our website. It's really fun. It's really interesting. Very, very well done. So I commend that to you. We are very grateful for city funding that helps make this program possible. It was supposed to be a live program with all of us in the same room, as you may remember, but we're delighted to be able to use technology that we didn't know about, or at least I didn't 3 months ago. The program is supported in part by public funds from the New York City Department of Cultural Affairs in partnership with the City Council. And our City Council member, Ben Kalos, has been particularly supportive of all of our efforts in Yorkville because he's born and bred Yorkville. He's the real deal. And he will join us on Friday. We're going to have a wrap-up session, kind of a free-for-all with a number of people who are involved in this, who will not be among the speakers in the next couple of days, but that should be a really very robust and interesting conversation. I want to call out especially someone who is in the audience today, and that is Mark Silberman, who is the attorney, the counsel for the Landmarks Preservation Commission. I want to call out Mark and the City of New York for the very diligent, devoted, concentrated, energetic, intelligent, faithful work they did on this case for a long, long time. It was brilliant, and it took a long time. The commitment of the city is really commendable, and Mark's work on it was phenomenal. And I should call out also John Weiss, who's an old friend of Friends. So thank you. And Mark will be joining us on Friday, so you will be able to hear more from him, or perhaps in the Q&A after the session here. And finally, many thanks to Friends staff. We have all of 2 staff members, essentially. Our acting executive director, Felicia Mero, and the wizard behind the curtain is Laura Sakin, who is our director of preservation and outreach. So you'll see her later when we get to the Q&A. For our moderator for last night and the other tonight in the series coming up is Lisa Ackerman. Lisa is a preservationist par excellence with a specialty in international preservation, really the worldwide scene. She is very, very knowledgeable, drawing in part from her time at the World Monuments Fund. She is now the executive director of the Columbus Citizens Foundation, which is devoted to Italian-American heritage and is located on the Upper East Side, I'm happy to say. We're glad to have her back. She was Midtown for a while, but she's back on the Upper East Side now, which is great. She teaches her field, the international preservation at Pratt, and is a favorite professor there. And our main speaker, our conversationalist today, is Will Cook, who is a preservation lawyer. I think of him as a specialist in preservation law, which is a very important specialty for people like us, but there aren't a lot of people who do it. So we're very glad to have Will with us. And he has a sort of a specialty within a specialty, which is described as a practice that focuses on balancing historic preservation with economic development so that historic preservation law is more efficient, effective, and predictable. The intersection between preservation and economics is very, very important. So we're glad to have somebody so smart and eager and interested working on that. And we're very glad to have him with us here tonight. And with that, I will turn the microphone, or whatever you call it, over to Lisa and Will.
Thanks so much for that great introduction, Franny. I'm really looking forward to our conversation tonight. As people were entering the room tonight, I saw some repeat visitors from last night. So both for those of us who were all together last night, as well as those of us joining just for tonight. Last night, we had a fantastic conversation with Andrew Jolhart about the history of First Avenue Estate, its context at the time in New York City, and its cultural context then and now. And I think that there were a lot of things that we took away from that conversation, but in many ways, it was that the reason for landmarking First Avenue Estate was multifaceted, as is often the case with preservation endeavors. And I think we don't often think about housing. I mean, we all live in some place. Most of us live in apartments in New York City. Some people are lucky enough to live in the city and in a single family residence, but we don't often think about how did we get there? What was the legal context for creating housing, for creating multi-dwelling housing, and what was really so revolutionary about these buildings in their time? And from Andrew, we learned a lot of it had to do with the way you lived, the kinds of windows you had, what kind of circulation there was, whether there was cross ventilation, what kind of sanitation improvements were there in the houses. Also, very much these were considered working family housing. So it was also about living in close proximity to the subway or to your workplace. And so it was all about facilitating a way of life. And tonight we want to turn our attention with Will to the legal framework. So the First Avenue Estate was built at a very early time in the city's history as the Industrial Revolution was taking hold and the population was growing. I mentioned last night that in 1800, the official population of Brooklyn was less than 100,000 people. At 1900, it was 1 million. So thinking about that kind of growth and the housing that was necessary and the conditions that reformers were trying to address. And so, Will, we turn to you tonight to tell us a bit about the legal context in which these houses were built, and then walk us through the very, very interesting legal struggle. A lot of us will go to the barricades for buildings for a lot of reasons, but we don't always know the legal side of it. So you're here to educate us tonight.
Well, I'll do my best, and I really appreciate the opportunity to be here. I'm a native Beaufort, South Carolinian. I'm proud to say that I had a wonderful 10 years living in New York City. On the Upper East Side, I was at 1100 Madison between 82nd and 83rd. So I've been a long supporter and believer in the work of the Friends. So it was a real professional honor for me when I worked at the National Trust for Historic Preservation in the Law Division to have a chance to assist on a Friends of the Court brief in support of the broad coalition of community groups that worked so hard for so long to protect and preserve First Avenue Estate, as well as the New York City Landmarks Commission, which did an incredible job in upholding the rule of law. Lisa, you pointed to one of the reasons why First Avenue Estate is such a fascinating preservation story. I think if I were to try to pick one case that I've ever worked on, this is certainly one that hits a lot of the bells and whistles. It was a path marking case, a path marking preservation effort for many reasons. You had asked me to describe the legal context, and I'd spent some time thinking about that again. It'd been some years since I'd worked on the amicus briefs, but I'd had time recently to talk to John Freeman Gill, who wrote just an excellent article, a very thoughtful article in the New York Times that many of you have probably read. It was published on June 19th, and it was called All Quiet on the Far East Side. But to me, it was just such a nice capsule and very thoughtful summary of not only the legal issues, but also the incredible social history that permeates the legal challenge and the advocacy fights that a broad coalition of community groups worked so hard to to bring about. When back to the point about the legal context, what's so fascinating to me about this as a building is that it didn't really have a set of rules to respond to when it was being designed and constructed and then completed in 1915. Most people don't realize it, but New York, which was the first city in the country to pass a comprehensive zoning law, passed that law a year after the First Avenue estate was built. The only other zoning ordinance I'm aware of that existed at the time in the United States was passed by the city of Los Angeles, which did not apply citywide as New York's did. And it divided the city or what portions of the city it had in fact zoned or included in a zoning map into residential and industrial districts. New York took that so much further in terms of how it regulated the built environment. But I think, again, it's fascinating to realize that law came a year after First Avenue estate was completed. So we didn't have the types of land use restrictions like setback requirements and, other zoning rules that would have required for light and air circulation. Some of the very factors that led to the passage of New York's comprehensive zoning law in 1916. Prior to that, as early as the 1870s and early 80s, New Yorkers started to protest the loss of light and air in response to taller buildings being built all over the city. And it reached a real flashpoint in 1915, same year that First Avenue estate was completed, which many of you will remember is when the Equitable building was built at 120 Broadway. And in particular, this building, towered over its neighbors. It used every available inch of its footprint on the land. It covered windows that were within neighboring buildings and cut off sunlight to a lot of the surrounding area. And that case in particular, I think drove a lot of the changes that came about with the zoning ordinance. But one could argue, and I've not had a chance to do the legal research, but I think it would be a great future study, but there are likely a number of ways that First Avenue estate influenced the way that residential housing would be built going forward, particularly in terms of sanitation and the provision of light and air and all the things that make large-scale housing more livable. And of course, this housing reform movement had come about largely as a result of housing shortages that were created or caused by an influx of new immigrants coming into New York City. That created a market for tenement buildings, particularly on the Lower East Side, that were built to maximum bulk and to minimum safety standards. So that sort of paints the backdrop against which the very progressive thinkers and capitalists that were financing and developing First Avenue estate were faced with. They were really creating a building in a land use vacuum that in many ways was prescient and predated the actual implementation of laws that govern New York City's built environment, including the move to limit residential buildings primarily to 3-story and 6-story levels, which of course First Avenue represents. That was done before the zoning ordinance was put in place. So I hope that gives a little bit of context. It was more a lack of legal context, I think, that makes First Avenue estate so extraordinary, and that it reflected a lot of what the zoning law was intended to do.
I think that's a very perfect backdrop for where we go next in our conversation, because I think it's important to understand, why buildings were built, how they were built, what made them flourish. So now if we flash forward several decades, landmarking is a complex web of local, state, and federal statutes. We all know that the local laws are where the teeth really are. New Yorkers like to say that we have, you know, the toughest, best preservation law in the country. And I'm not going to dispute that. But I, you know, think that we're all very proud of the way the preservation law in New York City has really looked broadly at what we're trying to preserve and the stories we're trying to tell, as well as making it a livable city. We're not trying to freeze anything in amber. We want to continue to be a dynamic place to live and work. So when this battle erupted, you know, I'm sure what was in everybody's minds at the very beginning was that this was a local fight. You go to the Landmarks Commission, you try to landmark something, you see where the chips fall. But this had a very long life as a legal battle, and some interesting twists and turns, as well as, you know, arriving at the highest court in the land. So that's a lot to take in. But, you know, I'm hoping you're going to pull out some of the highlights for us and what was really significant and what was the legal reason to keep going?
Yeah, and that's a good question. As you, I guess, a first point I'd like to make is that New Yorkers should feel proud of preservation advocacy and the New York City landmarks preservation law. It's one of the most robust, strongest local preservation laws in the country. I can't tell you how many have followed that model, but the influence of New York's local preservation ordinance is pervasive. And I know there's an often sort of, I would say, undeserved reputation that preservation advocates in New York are overly litigious. I would argue that laws don't amount to anything until they're tested and enforced. And so I've always had a lot of respect for preservation advocates in New York who've not shied away from legal fights to make sure that the landmarks ordinance means something. And oftentimes, like with the First Avenue estate litigation, that means standing up for the hard work of the New York City Landmarks Commission, which is another, you know, wonderful layer to this. I mean, this was a case where the preservation community was backing the Preservation Commission for doing exactly what it was supposed to do in terms of applying the letter and intent of the landmark preservation law. So I hope that adds some helpful, I guess, backdrop to it. The other side, positive side to not being afraid to bring lawsuits or to defend vigorously lawsuits that are brought against the Preservation Commission, which is what happened here, is that New York has also been incredibly influential in the development of historic preservation law writ large. Because of this vibrant advocacy community, many important, and I should say landmark historic preservation cases have been decided by courts in New York City, which have created legal precedent for other communities and courts in particular follow. So there's a lot to be proud of in terms of the history of preservation legal advocacy in New York. When I was had a chance to talk to John Freeman Gill when he was working on his law review article, it gave me a chance to go back and study the very complicated procedural history that led to the different stages of legal advocacy in the case that I'm not going to cover tonight, but it was a good refresher course. And I thought I'd point out a few of the highlights. I mean, many of you in this Zoom room had a lot to do with the evolution of this battle, but you know, I think it's fascinating that the Landmarks Preservation Commission, again, was ahead of its time in landmarking a property like this that was really at the intersection of historic preservation, urban land use, and housing. And this was in 1990. The Landmarks Commission gave its first designation to the First Avenue estate. I point out that it wasn't until see if I have my date right. It was September 15th, 1994, that the National Register of Historic Places listed First Avenue Estate in its inventory of nationally significant historic places. So again, New York Landmarks Commission was ahead of its time and thinking more holistically about designating historic properties, not just based on the significance of architectural merit, but also looking at the types of buildings that one might describe as vernacular or ordinary. And I don't mean that in a disparaging way, but that I think that seems to have been a real flashpoint for First Avenue Estate. And I noticed that it's still alive and well. And a lot of the comments that I read in response to John Freeman Gill's article in the New York Times, I was checked out a lot of comments today, and there was a lot of, sort of comments about how there's nothing special about this building. It looks like a million other buildings, but that's not the point of historic preservation. This First Avenue Estate was a first for a lot of the reasons that I described earlier, and that deserved recognition and fit the Landmarks Commission criteria that are contained in the Landmarks Preservation Law. So, starting with this very, I'd say, first of its kind decision in 1990, that was met with this almost immediate reversal by the now defunct Board of Estimate in August 21 of 1990, when the Board of Estimate removed the designation in a very contentious 6-5 vote. We all know that the Board of Estimate was disbanded. There was subsequent effort to redesignate First Avenue Estate, which happened on November 21st, 2006, shortly after the property owner started to remove portions of the facade on 2 buildings and paint them a pink stucco color. So I think that's to me, those are some of the interesting points in the procedural history. Just this back and forth, sort of like a tennis match between the Preservation Commission, Board of Estimate being removed, Landmarks decision making, redesignating the property. And then I won't get into all of the myriad details of the state and federal lawsuits that started after the designation was finalized. But there's literally like a 2-page summary of a procedural history that followed after that. So this was just hard fought, tenacious legal battle from the very beginning.
Great. Well, I want to pull out just a few things that you said, because I think that they're very, very significant, not just for First Avenue Estates, but in general for preservation. One is the landmarks law was very forward-looking. As you said, it's really about envisioning land use. And so preservation becomes a tool in urban planning, as well as the way we apply land use strictures to what we do. And I think that one of the kernels that's embedded in the landmarks law, which indeed the Landmarks Commission in New York City has a tough job on any day enforcing. And I think here they were challenged in ways that were very, very significant. And the fact that the Landmarks Commission really, it's an ever-changing group of people. There's a different there every so often. There's commissioners who are volunteering their time. So it's not always the same people today as who fought the battle initially. But I think from a philosophical point of view, the commission really understood what was at stake here. So beauty is in the eye of the beholder, but significance is not only the physical beauty of a place. And I think here, one of the main reasons for landmarking, and what really kept coming up in all of the court cases, was in the landmarks law, there was a phrase around cultural significance. So it wasn't limited only to the vagaries of what's beautiful at any moment in time to us. And so here, the breakthroughs and what made it unique were all the things we talked about last night with Andrew and a bit with you in the initial parts of our conversation, that it was about the way the apartments were constructed, the amenities, if you will, that were embedded into the building and that were still there. So if you lived in the building today or you lived in the building 100 years ago, you still had cross ventilation, you still had good air circulation, you still had high standards for construction technology. And so I think, we often think of preservation as something that's only what you can see with the naked eye. And this was very much about what was inside the walls that you couldn't see.
Right.
So I think it was very commendable that as it moved its way through the court system, the various people reviewing this from a legal standpoint really had the surety that the original law, as it was written, envisioned one day you might be talking about something that wasn't immediately obvious why it should be preserved. And, I just wonder, I have an intuitive sense that that's still sometimes an unusual thing for people to get behind something that can't be classified as strikingly beautiful.
Yeah. Lisa, if it's okay, I wanted to share an image
Absolutely.
with our group, just to make the point I think that you're making so eloquently. I just wanted to show you a couple of images that many of you have seen. This was a photograph that was shared with the New York Times, John Freeman Gill from the Friends of Upper East Side's collection. I think it just gives such a great vantage point of the height, scale, and mass and of the building in terms of how it occupied that block. But then in the next image, again, back to this idea of detail. A lot of people, I think, miss the detail when they look at this building. If you look at the image on the left, I'm showing you an advocacy piece that was used during the fight. But I wish I had the ability to zoom in on the image on the left. But, if we could, you would see, really lovely patterns of brick, marble and terracotta architectural elements that were stripped, at least with respect to two of the buildings, from the facade of the building as a way to potentially create enough harm to the historic integrity of the building, such that it could have or might have prevented landmarking. And that's what's illustrated by the image on the right, when the brick and the terracotta architectural elements were removed. The facade was then covered with the salmon colored stucco. And I think, again, this draws a contrast, very starkly between what was there originally and then what was there, I think it was, in 2006, prior to the redesignation or reinstatement of the original designation by the Landmarks Preservation Commission. And an important legal point here that came out in the hearings before the Landmarks Preservation Commission and in court was that these two buildings that were, let's say, defaced, didn't represent the entire, were not representative of the entire block. And there was enough intact of that entire block that, the mere diminishment or harm to the integrity of these two buildings was not enough to destroy the historic significance of what the First Avenue estate conveyed altogether. So that, I think, is another important piece to the story, that even though these particular two buildings were the focus of the property owner's efforts to demolish and redevelop, they were part of a whole that remained intact. And in fact, the property owner had maintained the facades of those buildings, and they, along with these two buildings that appear in salmon color, continued to be occupied over time, which was a fact that cut against the hardship exemption arguments. So I just wanted to, for those who might not have been familiar with the contrast of images, I wanted to just to share that, and also just to add that important legal piece to the puzzle that the Landmarks Commission did not limit its review to these two individual buildings of the larger block. this gets into, I don't want to get too far into the legal weeds about parcel as a whole, but it's an important legal concept when we're dealing with challenges to development rights, that you look at everything that the property owner owns on that block or on that parcel.
I think that's a great summary. And again, I think that's really the crucial element, that the defacing of the buildings by removing historic elements, because the physical adornments were not really the basis for the landmark decision, taking them away is sad, but the basic reasons why we cherish First Avenue State is still there. It still was the breakthrough construction technology for urban housing of its day. It set a high standard. It led to laws that we continue to have on our books that are standards for multifamily dwellings. And it's also in many ways a sort of beacon for some of the issues we're struggling with today about affordable housing and envisioning our city going forward and development. So it really stands as a terrific chronicle of the history of the city, as well as this very important legal battle. So we're going to switch to Q&A with our audience. And before we get there, a few questions that have already been circulating that I want to lob to you. One is, what are the preservation legal issues on your mind today? A second question, from somebody who, lodged a question earlier today, which is, it's an unusual specialty to go into preservation law. And I don't know if you woke up one day and said, I want to be a preservation lawyer, or if you just found yourself there. And if somebody wanted to pursue this, I mean, if you go to law school, is going into land use and preservation a part of a curriculum you can guide yourself to if you're sort of interested in civic affairs? And I think that's where we'll leave it for you to answer those. Then we'll go to broader questions from our audience.
Yeah, sure. I guess I'll tackle it in reverse. Maybe talk about why I'm doing what I'm doing, and then I'll answer the question of a key legal issue I think a lot about, that again has direct relevance to First Avenue Estate, and again ties directly to the evolution of preservation law in New York City. So when I came out of law school in 1996, there were no real preservation law jobs that I knew of. I was connected to the law division of the National Trust and had a chance to work with my mentor, or meet at that time, my mentor, Betsy Merritt and Tom Mays and Paul Edmondson. I met them this summer. I think it was summer of 1995. I was applying as a law clerk at law firms all over the, in Washington and New York City. And I just sort of learned about this field of historic preservation law and was fascinated by it. I grew up in a town, sort of steeped in history. My father was an American history professor, so I guess I had that ethic built into me. I mean, I like old houses and old places and the histories that could be conveyed by their continued existence. But I in full candor, I was not hired as a law clerk at the National Trust, a distinction I love to share with my former boss, Paul Edmondson, who's now the CEO, and was previously the general counsel. We weren't in the summer intern program, but I stuck with it and looked for opportunities to get involved. Became an appellate law clerk. Spent a lot of time developing legal skills at a large national civil litigation firm. And then when I had an opportunity to join a board of the Preservation Society of Charleston, which was the first community-based preservation advocacy group in the country, I started to get more involved in the legal advocacy side of things. I was a full-time property law professor at that time. I was also teaching constitutional law and developed one of, I think, 3 preservation law courses in the country at a law school. If I were pursuing this today, there are many more opportunities to, I think, explore that nexus between preservation and law. I've been very fortunate and proud of my association, which I think Andrew, thanks to Andrew Dalcourt and Tony Wood for introducing me to the graduate program of architecture planning and preservation at Columbia University, which I think is a wonderful resource for lawyers who are looking to get, or law students who would like to have more information about how preservation and planning work. I think if I could change something in the way that preservation is taught, is that I'd want to integrate it more with planning, architecture, and vice versa. I think it tends to be taught in buckets in graduate programs, but in fact, each of the disciplines really fully inform one another. If I could go back and do something again, I would like to get more planning experience and just overall land use experience. But there certainly is a path for this. It's a narrow path, but I'd be happy to explore with anyone following the talk tonight about some ideas for how to get into the legal side of the field. In terms of important legal issues in preservation, I think a lot about. I'm just going to share very briefly a couple of images just to remind everyone. I'll go back one more time to my slides. Just to remind everybody that another one of the reasons why it was so important to help support the city in this challenge was that there was a regulatory takings component to it. The property owner was suing the city just like a property owner had done in 1978 when Penn Central was saved. And I won't say a whole lot about it. I mean, it's one of the most fascinating and important preservation law cases that there is. It was the first preservation law case ever decided by the Supreme Court of the United States. And in addition to upholding the validity of the New York City Landmarks Ordinance, and this is a case involving air rights in a way much like First Avenue Estates did too. And like First Avenue Estates, the Landmarks Preservation Commission was sued. And using the argument that you're not allowing us to do something that we want to do with our property. And you, the city, need to compensate us for the loss of the rights. And from Penn Central, this regulatory takings case was established that answered the question, can a city regulate in the area of historic preservation? And the test is still in existence today, continues to be followed by federal and state appellate courts all over the country, and it's still the key test or controlling test that's used by the Supreme Court. Won't get into all the balancing factors, but this was another one of the reasons why it was so important for preservation groups to do everything they could to support the city's decision, and also got the attention of the National Trust for Historic Preservation, which recognized the national significance and the precedent-setting nature that First Avenue Estate could have had there been a contrary result. So as we know, at the end of the story last year, the Supreme Court of the United States denied a second attempt by the property owner to have the Supreme Court second guess the decision of New York's highest appellate court that no taking had occurred. And this is an incredibly important issue. And I think beyond First Avenue Estate, this is a challenge that local communities and local preservation groups face almost every day, having to uphold the validity of their law against a well-established takings test that arguably should not continue to be litigated. I mean, it's pretty easy to predict how a court will rule today, and First Avenue Estate did not fit into the box of a case that would have gone in a direction away from the Supreme Court's decision in Penn Central.
That's great. Thank you so much for taking us through that. I'm going to ask Laura to join us again because she's going to be the master of Q&A. And I'm going to see if Laura has some questions queued up for us.
Yes. Hello, everyone. I'm Laura Sicking, from Manager of Preservation at Friends of the Upper East Side. And before I start reading the questions that we received, I want to ask everyone to turn on their videos, go into gallery view, so we can have a conversation about everything that is going on while seeing each other's faces, which feels at least feels a little bit closer than as if we were in person. So we do have very interesting questions today, and the first one is from a fellow preservationist, Brad at NIPAP, and he's asking that when the New York City Preservation Organization mounts a legal challenge, should other preservation organizations also file amicus briefs, even if those briefs are very succinct, like one-page briefs that speak only to the interpretation of one central question of the law? Does that signal to the court that there is a widespread support for an interpretation in the field, or does the court just get annoyed by this?
Yeah, it's a good question. I don't think courts get annoyed, but as a practical matter, it's very difficult unless you have a lawyer who's used to litigating, especially at the appellate level, to file an appellate brief without legal representation. There's so many rules and procedural steps that have to be followed that it's easy to make missteps. There are a lot of formatting requirements, and so my advice would not. I mean, if one could find a lawyer to represent an organization, that would always be the best way to go, just because there's so many ways that could prevent an amicus brief from being accepted by the court, a lot of technical requirements. So I think maybe one way to balance that, and that's what community groups did really well in First Avenue Estate and in Penn Central, is that they developed a broad coalition of supporters that were able to then hire legal counsel to represent them as a group. And to me, that always sends a strong signal to a court that there's large, broad-based community support. There's an opportunity in an amicus brief to set out, exactly the types of communities that groups represent. And so, if anything, the broader the coalition, the better. Oftentimes, again, one way you can minimize costs, best case scenarios, you can find a pro bono counsel. But if that's not possible, there could be a way to share costs. Sometimes, especially in a case like this, the National Trust will get involved and maybe write a brief, or other groups could write a brief that other organizations could join. So I would say, if I were giving advice to local preservation groups as they work on that coalition building, find a lead organization that could mount the fight. And if pro bono assistance isn't available, find some way to share costs, but combine forces. That would be my advice, to avoid all the pitfalls of trying to file something on your own without legal representation.
Thank you. Also, you've both mentioned how preservation is handled in very different ways across the country. Are there any resources that you can recommend for those who are interested in preservation law? And most of us know how to stay abreast of preservation news and legal issues in New York City because that's our field. But how do we learn what's going on elsewhere?
I mean, I'll take a stab at this. It's a problem in local preservation law to keep abreast of what's happening all over the country. There are close to 3,000 different local preservation ordinances. And so, as a practical matter, it's hard to monitor what's happening in cities all across the country. One way I do it, like many of you, I try to sign up for as many kind of preservation Google alerts that I can. That's made it much easier than it used to be. Joining groups or signing up for mailing lists, like the Friends of the Upper East Side. I'm on email lists from the Landmarks Preservation Commission, planning commissions. I try to get as much news as I can from different sources. Unfortunately, there's no clearinghouse for local preservation law. The National Trust years ago published a layperson's guide to historic preservation. I think gives a good overview of how federal, state, and local preservation laws, how they work. But it's a very good question. I wish there were a better clearinghouse of what's happening, on a daily, weekly, monthly basis. I get most of my information from colleagues, from blog posts. And then again, today, I think Google alerts are invaluable. Westlaw, LexisNexis have alert features that can send preservation cases to you as they're decided. But one of the, I think, problems as a lawyer is that you're often not brought into a preservation fight until very late in the game, when maybe a faulty administrative record's been created. So if a preservation group, really wants to take on a battle, I would say get some legal advice as early as possible, before you even begin the administrative process. Build a legal advocacy committee, or a group of advisors. They don't have to be board members even, but that just can be there as a sounding board for you when a legal issue comes up, so that you can marshal those resources from the beginning rather than after you've gotten an adverse decision that can often be hard to defend in court.
It's actually kind of amazing in today's world that there isn't an aggregator for
I know.
land use cases or preservation law. This sounds like a great challenge for some of us who teach in preservation programs. Maybe we have to find out if there's a student project we can launch to develop an aggregating tool, because
It's on my wish list.
well, that's good. We'll keep that in mind. But I think we have time for one more question, if there is one.
We do have a really interesting question. So when you guys talk about cultural significance, we're talking about intangible values. How do you regulate intangible values?
Lisa, I'll let you start with that. Well, no, I have some ideas, but
sure. I mean, I think you can't regulate values, but our laws come out of a shared set of values. And so that's why the best laws are written rather broadly, because our values do shift over time. Our demographics change, the things that concern us at any moment in time change. And so the best laws are those that allow for the fact that a law you write in 1965 doesn't have to last until 1966. It has to last as long as possible with a shared set of values. So I don't think you're regulating values. I think you're regulating a quality of life, which you can. You can regulate the amount of light that is required. You can regulate height. I mean, I think, as Will pointed out early on, these are land use issues ultimately. And the preservation law comes out of a desire to add a layer, to that particular municipality that says, in addition to the concrete things we can regulate, like the height of a building or the amount of air circulation, we want to make sure we bring with us some history that's important to us, that embodies important values that we recognize today. So 50 years from now, if somebody says none of this matters anymore, then you strike laws from the books or you adapt them in some way. But I think the regulation is not so much the intangible. The regulation is very much about a set of physical things that we can regulate.
Yeah, and that's exactly what happened here. I mean, we speak about the cultural significance that the building represented, but Lisa made an important point. It's absolutely correct. The basis for the Landmarks Preservation Commission was based on physical factors and the ability of the historic structure to convey its meaning through the physical components that it embodied. I mean, it's this embodied cultural heritage, but the designation was made on physical factors, the history and the reason why the building was built. So I could see a scenario. There are places that are starting to attempt to regulate buildings for cultural reasons only, but that I would underline that was not the case here for First Avenue Estates. There are lots of cultural heritage components that help tell the story about the building's significance. But the designation was very much rooted in the Landmarks Preservation Commission's existing criteria that they apply every day to myriad building types.
Thank you so much. You know, I want to keep us honest. We said we would have about 45 minutes with you, and we're a little bit beyond that, but I think a fruitful conversation. So Will, thank you so much for joining us tonight. Thank everybody for joining us tonight. And if you joined us last night and tonight, we're very grateful that you're hanging in there with us. Tomorrow, we're going to speak with Tony Wood about the community engagement factor. So as I said last night, none of this happens because one single person goes to the mat for First Avenue Estate or any other structure. A community really came together. And I think one of the breakthrough moments with First Avenue Estate was that it was not just preservationists going to the barricades. It was a whole constellation of community groups that cared about affordable housing, cared about the streetscape, cared about environmental issues, and yes, cared about preservation. So with Tony tomorrow, we're really going to explore a selection of those community groups, because since there were nearly 200 groups that came out in support of First Avenue Estates, we won't get through all of them tomorrow, but we'll really try and hit the highlights. And then Friday, the speakers will come back. So Andrew Dolkart, Will Cook, and Tony Wood will join us all again, along with some special guests to have, I don't know that it'll really be a wrap up so much as, you know, a forward-looking conversation about, with this celebration that the First Avenue Estate is landmarked and definitively so, where do we go next with all of this? So I'm going to turn to Felicia and Laura to ask if there's anything else that we need to say. And if not, I'm going to thank Franny for introducing us tonight, all of you again for coming, and I hope we'll see you tomorrow. Good night, everybody.
Good night.